Hello, and thank you for joining us on our journey through intellectual property law. We're going to be talking about a number of various topics over 14 different short videos designed to help bring legal English into your practice of the law. With this series, we hope to show you how intellectual property law works around the world and in the United States with some specific terminology and grammar usage that will make you a better lawyer. Before we go on, my name is Jeff Keiser. I'm a lawyer from the United States that's been working in various areas of the law for almost 15 years now. I've worked on some of the largest cases in the world, especially the BP oil spill case that resulted from the oil spill in 2010. But I've also been a legal English teacher for about 5 years now, helping people from around the world learn how to use English in their work and in their lives. I am a global traveler. I love different cultures. I love interacting with people from all over the world, and I hope that you enjoy these classes very much. So, let's start from the point of view of what is ownership, and is intellectual property much different than real property, as in real estate, a home, or a car, or even the phone that you're probably looking at right now. Ownership is the legal right to use, possess, and give away a thing. It's that simple. It can mean control over a tangible good, like a house or a car, or it can be intangible. And that's what we are talking about here when we're talking about intellectual property rights. So, what are intellectual property rights? These refer to the legal rights given to the inventor or creator to protect his or her invention or creation for a certain period of time. That definition is a little bit tricky, I understand, but it's really quite simple when you break it down into those parts. And we will absolutely be breaking them down throughout the course of this video series. Basically, if you create something, you have the right to do with it as you please. So what kind of legal concepts are we talking about here? Well, there's a lot of them, and we're going to cover them separately for the most part. But in this introductory video, we're going to keep it a little simple. And it applies to anything from trademarks, to copyrights, to patents, to trade secrets. Those are the main forms of intellectual property. But this affects everything from industry to the legal profession, obviously. It impacts the brands that we consume on a regular basis. Now, I guess the real question that we all care about very much is who has IP rights? And the short answer is, it's the people that create them. It's the author of the work. J.K. Rowling is the owner of the intellectual property of the Harry Potter universe. It's that simple. If you create something, it's yours, and you can do with it as you please. Throughout this video series, we're going to have several what I call vocabulary time. And it's when we're going to speak about some specific terms that are used in this area of law. For example, an author. It's not only in the literary world that we talk about authorship. An author is the creator of an original work. and they are granted exclusive rights under copyright and other intellectual property law. So you can author a patent or a trademark or a copyright. If you create something, you're the author of that thing. Registration. Now, we often think that registration is the only way that we can protect our intellectual property rights. And it is one way that we can do that. By registering our intellectual property, whether it's a trademark or a copyright or especially a patent, that allows us to tell the world that this is our original work and that no, you cannot use it without our permission. We will be going through that registration process a little bit as we get into the topics in a little bit more specificity. One thing to consider is that with any type of intellectual property, there is a concept called the work for hire doctrine. And that means that if you are an employee of a business that hires you to write a book or develop a trademark or register a patent, generally speaking, those trademarks and copyrights and patents are owned by your employer. It's almost the reverse of vicarious liability, which is an entirely different legal subject. So when we create something for ourselves, it's ours. But when we create something for our employers, it's probably theirs. And that leads me to the real issue is how we can maybe buy or sell or otherwise transfer intellectual property. And most countries, the United States included, allows people to freely transfer their intellectual property as they see fit. They can sell it outright, they can license it. If they're feeling especially generous, they can even donate it. But I will say that under American law, 17 U.S.C. sections 101 and 201 through 205, any transfer of a copyright ownership is not valid unless it is in writing and is signed by the owner. So there's no oral contracts when it comes to the transfer of intellectual property. There are four main devices that we can use to protect IP rights. The patent, which is based in technical inventions like chemical compositions of pharmaceuticals or mechanical processes like complex machinery. Those are all handled by the patent world. There's the copyright world, which handles things like artistic, literary, or intellectually created works, like novels or music or movies, software code, that kind of thing. A trademark is a word, phrase, design, or a combination of those that identifies your goods and services. It distinguishes your product from another's product. When it comes to a trademark, think about the shape of a Coca-Cola bottle. That's one. When you think of a patent, think about a new type of hybrid engine that you've designed. When you think about a copyright, think about the song lyrics from Let It Go from Frozen. I won't sing, I promise. We'll talk about trade secrets towards the end of this series, but it's a very unique type of intellectual property right. One last thing that I want to talk about very quickly before we move on is the reality that international patent law doesn't exist. Each country has its own system, and so if you file for a patent in the United States, it will not protect your product being used in the UK or in India. Copyright is a little bit different, where many treaties have been developed, but patents are largely on a country-by-country basis. And that's it. It's that simple. That's our very first video in the series. And in our next one, we'll be moving on to patents. We'll talk about what you can and cannot patent and a little bit about how it works. Thank you so much for spending the time with me. I hope this has been educational and informative. And if you have questions, please feel free to send me an email. I'm sure that my contact and Josh's contact will be linked somewhere in this series. In the meantime, have a fantastic day, and I'll see you soon for more intellectual property law.